the distinguished Vice Chancellor of this distinguished university, the teaching staff who are serving here and serving the great cause of education of the young, all other guests, and my beloved students, charming ladies, and slightly less charming gentlemen. Palkiwala was a great friend of mine, and we remained friends till the last day of his life. But I must tell you one habit of Palkiwala. He accepted invitations to go and speak, but never spoke about the subject assigned to him. He exercised what he called academic freedom, but then, not to be too disrespectful, he said a few words about the subject for which he had been invited. I don't follow him completely, but I must confess that I follow him substantially. First of all, I know that you are all interested in becoming great lawyers, but I must tell you that I do not approve of lawyers who only know law. A lawyer who only knows law is a mason, a worker. What we need amongst the lawyers is that they have to be architects. And my friends, when I come to deliver any lecture, either in the classroom or this kind of a broadened classroom, I take into account that we need lawyers in the true sense of being architects of the nation, builders of the nation. Well, not that I am not going to speak about the subject, but first of all, let me tell you that Mr. Palkiwala made great contributions to the growth of our constitution. But it is somewhat unfortunate that he was not a criminal lawyer, and therefore you will not find much of his influence in the development of criminal law. He was a constitutional lawyer, pure and simple, and his developments of the constitutional law are also wonderful. But I am afraid some of the developments of constitutional law in which you are interested, he had very little to say. He appeared, of course, during the emergency before the Supreme Court. I also appeared. I was the chairman of the Bar Council of India at that time, and there was a warrant out for my arrest issued by that great lady from the Gandhi family. The Bombay High Court had granted a stay of execution of that warrant, and I appeared before the Supreme Court certainly to oppose the emergency and to expose what it had done to India's constitution and democracy. But incidentally, the Bombay High Court had stayed my arrest, and I was carrying that order of stay of my arrest in my pocket, which had made me so irresponsible that there is not a great place in India where I did not go and said the foulest things that could be said about that lady who had imposed this emergency on India. But then it is a great tribute to the just judges of this country that 9 high courts had held that despite the emergency, courts are fully empowered to protect human liberty. And they were doing a wonderful job. It is against the judgments of these 9 high courts in India that the dictator took an appeal to the Supreme Court. And of course, I wanted to appear before the Supreme Court, so I asked one of the detainees. I could have appeared because I was myself a detainee. But I went as a lawyer. I remember when I opened my speech before the Supreme Court. So I said, my lords, you might think that I am appearing for this petitioner who has engaged me in this case. Doubtless true that he has. But please don't remain under that superstition. I am appearing for the millions of detainees who are rotting in India's jails, and their only protection is the judiciary. And the judges in the high courts have so far protected them valiantly. And this is an appeal brought to your lordships so that you should destroy the conscience of the judges and convert them into slaves. So, the Chief Justice Ray almost jumped out of his chair. He said, Mr. Jethmalani, did you really say that? I said, yes, my lord, I not only said it, but I now wish to remind you of something which is not meant for 4 other judges, but only for you. There was a judge in Ghana who helped the government to draft the preventive detention law of their country. He had taken no other role. He was not a supporter of the preventive detention jurisprudence, but he just helped them to draft that legislation under which preventive detention was being introduced in that state. When that law came into force, ironically, the Chief Justice was the first to be picked up under that law. And nobody heard of what happened to the Chief Justice for the next 2 years until there was a cryptic announcement in the press that the Chief Justice died of natural causes. I said, my lord, that's the fate which awaits all 5 of you. After that, the Chief Justice was quiet throughout the hearing. He heard me fully. And when I was concluding my speech to the judges, I said, my lord, Indian democracy is yet not dead. I agree that it is in the coffin, but I hope that it will not die. And I am here to see that it does not die. Well, I stopped at some place after 5 minutes. You know what happened then. By a majority of 4 to 1, all the 9 high courts were set aside, and the Supreme Court delivered the most disastrous and scandalous judgment ever known to judicial history. That one great judge redeemed the honor of Indian judiciary, the Justice, you know that great judge, for whom an article appeared in the New York Times that here is a judge who deserves the gratitude of posterity in India, and he deserves the admiration of every freedom-loving citizen of the world. And I hope the free world will build a monument to the memory of this great judge. My friends, a time might come in your history too in your life too, that you might meet the kind of situation that I had seen in that vicious year of 1975. It can happen again. Democracy is still in danger, and that is why I do not, like Mr. Palkiwala, stick to the subject assigned to me. But the most grave necessities of the time. You lawyers, you young lawyers particularly, must brace yourself for becoming the defenders of India's democracy. And I assure you that democracy is as much in danger today as it was in the year 1975. And I still see signs of it happening. That what is happening is that more and more vicious laws are being enacted in the name of sustaining the rule of law. But the real purpose of those laws is to take away the human rights of every citizen and to prevent the exposure of the corrupt and the corruption, and to see that somehow they get along with their vicious designs on the human beings who call themselves citizens of this unfortunate country. My friends, those of you who have read some history must have known that there is a period in human history called the Dark Ages of the world. It is said that these dark ages existed in Europe and therefore the world, because Europe was the world at that time, from about the 6th century to the 14th century. And how was this age, how was this calculation done? The calculation was that the rule of the Romans and the Greeks had come to an end. The rule of antiquity had come to an end, and some other rule had come to be imposed. And that came from whom? Came from the Christian powers and Christianity too. But my friends, ultimately the bad name given to Christianity, to this age, the dark ages of Europe, was given by the Protestant movement, because they thought that all the fault was done by the Christians, by the Catholics. And I must say, and that is, I am very anxious to say to you, I hope there are some Muslim students sitting here. I hope even if they are not here, I hope somebody will report to them what I am saying about the Dark Ages. The Dark Ages of history is that period which produced Islam. My friends, I am a Hindu, but I am a great admirer of the Prophet of Islam. I admire him because I have a rational attitude to all religion. My attitude to religion is that ultimately religion must surrender to science. And I try to find in every religion an attachment to this great principle of my own existence. And I find that there is no other prophet in any religion, including Hinduism, who said what the Prophet of Islam said. And if there are any Muslim students present, please go back home and tell everybody what Ram Jethmalani said about the Prophet of Islam. He is the one prophet who told his followers that when you walk in the path of knowledge, when you walk in search of knowledge, you are walking in the path of God. He is the one prophet who added another corollary to this great theorem of his, that the ink of the scholar, mind you are all scholars here, and I am telling you the tribute of the Prophet of Islam. The ink of the scholar, he said, is holier than the blood of a martyr. And while historians, Christians and others are writing about the dark ages of history, it is a match going on between Catholics and perhaps the Jews and some others, but everybody has forgotten what the Prophet of Islam did. And my friends, I am so tempted to share a few minutes with you about what happened while the Muslims were following the Prophet's teaching. Muslims became the rulers of the world. They went and conquered even Spain. To cut things short, there was a Muslim scholar who was invited by the Khalifa to go and live in his palace. He declined the invitation. He said, "No, sir, I can't come." So the Khalifa insisted that, "Why? I give you all facilities for your study. I will not interfere with anything that you do or say or write. But tell me the reason if you are not coming. Why not?" Do you know the reason that he gave? The reason he gave is, "Sir, if I shift to your palace, I require 400 camels to transport my library. And today I have been taken to the library of this college of yours. And I am very proud of this college and I am proud of those who collected this library. But this great scholar of Islam refused to go and live in the royal palace because he didn't want to shift his 400 camels worth library and he wanted to be with his own books." And to cut this story short, for 13 centuries, Islam spread education because they were following the teaching of the Prophet. In the 13th century, Islam got a mad Khalifa. Burn all books except the Quran. So all those books which required 400 camels at one time had to disappear. And my friends, Muslims became the slaves of the very powers whom they had educated in the first instance. And therefore, I don't believe in the Dark Ages theory. Dark Ages did exist in some way, but it existed in those areas and in those patches where religion was not subject to science, where education was not superior to illiteracy, where the teacher was not respected much more than the uneducated fool. And I am here to warn you today that while you are sitting across me and in my front, please remember today that the Dark Ages exist today in the year 2016, and it is the role of lawyers and trained lawyers to put an end to the Dark Ages which are in existence. Politicians will not admit it. Politicians are the cause of the Dark Ages in this country, and they are therefore not interested in encouraging great institutions of education. These are the temples of democracy. Democracy without education is hypocrisy without limitation, and that is precisely what is happening. I am happy that you are here. Well, but I want to tell you that the story of the Dark Ages is practically false. After all, when you say there were Dark Ages, it is being said by the Christians. They don't want to pay attention to what the Prophet of Islam had achieved during that very period. But the Muslim friends also don't know their history. And today we don't have the real version of Islam. We have a counterfeit version of Islam, which I call the Wahhabi Islam version, which has nothing to do with the Prophet of Islam. Well, what you see now is Wahhabi Islam. This ISIS, what is it? It is a terrorist organization which wants to go on killing people, disturb the peace of the world. And today, these terrorists are not the simple terrorists of centuries ago. They are terrorists who have nuclear power in their hands. Once they put their hands on the nuclear power, be sure that the world is doomed forever, and they will first destroy the real Islam, then they will turn to others. And I don't know whether anybody will survive, because the nuclear power used on a big scale, which ISIS wants to do, is something which is a total threat to the existence of the whole world. So it is these dark ages, my friend, in which you lawyers and budding lawyers and good lawyers are functioning, and that is the part to which I wish to address myself today. Please think of this and be great exponents of free education. You are citizens of India. Those of you who are have at least sworn loyalty to the Constitution of India. And mind you that the Constitution of India has proclaimed its attachment to what we call secularism. What is secularism is the first thing which lawyers should know, and they should know it better than everybody else. My friends, secularism is the superiority of knowledge over ignorance, education over illiteracy, reason over false belief, and finally, the superiority of science over religion. I am conscious, I am a student of what the scientists have achieved in this world. Their achievements have been great, great, great. On the other hand, every great scientist has also committed errors. And there is a book which I will recommend to you. There is a book called the most monumental blunders of the world. These are blunders committed by the greatest scientists like Darwin and Einstein. And make all the students read these kind of books, and you will come to know that today we are wedded to secularism. Secularism means no false belief, rational belief. Maybe that rational belief itself be sometimes wrong. It is better to be by that belief, because that belief, at least in your own mind, is capable of being changed, and not like a religious belief which is not supposed to change at all. And every day, and I wish to quote one small little illustration. I am ashamed as an Indian citizen that in this country there should be a controversy over Bharat Mata Ki Jai. What is this going on? Bharat Mata Ki Jai. Does anybody understand what this really means? Bharat Mata is the name given to the soil, the ground, the earth of India. Does not the earth provide you means of sustenance? Does it not provide you food grains? Does it not provide you metals? Does it not provide you every possible luxury for your sustenance? And what does a mother do? Mother also looks after her children by sacrificing a part of herself to look after the children. In that sense, the whole earth of the universe, the whole earth of this planet is a mother, because the mother takes care of the entire population and growing populations. And if you say that glory be to the mother, there is a Muslim idiot who said this morning in the paper, Islam doesn't permit it. In other words, Islam tells you not to give respect to your mother who takes care of you through thick and thin all your life. The lawyers must learn to speak up. Please go against these people who talk like this. They are taking liberties under the Constitution of India, the freedom of speech guaranteed by the Constitution of India, and then trying to suppress that speech by telling people not to show any respect for your mother. The earth is the mother of everybody. It sustains Muslims, it sustains non-Muslims, it sustains everybody. So my friends, we are in the dark ages of history today, and these dark ages have to be ended, and the greatest contribution can come from the universities, and particularly the students of law and the budding lawyers who are going to take ultimately the charge of this country. I want lawyers to be proud of one fact, that it is lawyers mainly who produce the Constitution of India. Who were sitting in the Constituent Assembly? Of course, there were bureaucrats and others and so on and so forth. Ultimately, I consider that the Constitution of India was mainly the intellectual product of Dr. Ambedkar. The kind of document that he has produced is a document of which everyone should be proud. And for one reason and one reason alone, that Ambedkar produced this great constitution, you must be very kind and helpful to those communities of India to which Dr. Ambedkar belongs. And please see that there is no rivalry between the two. The politicians are out to exploit even that, and they will not allow you to do justice to the memory of the great, great constitutional lawyer, a constitutional author, and a person who literally is responsible for 90% of the work on the Constitution of India. Now that apart, now you come to this small little topic that you have kept for today. It is small as well as big. What I want you to do is that tomorrow one of your guests is going to be Mr. Datar, right? He is going to speak to you. What is the subject that you have assigned to him? Huh? Oh, Palkiwala's contribution. Oh. Datar has produced a great book on the commentary of the Constitution of India. In that, please pluck off the pages of his commentary under Article 21 of the Constitution of India, and you learn everything that you have to learn on this subject on which you have asked me today to speak. Tomorrow, interrupt Mr. Datar and tell him that we want you to supplement what Ram Jethmalani has told us yesterday, and your fixed speech we will hear some other time. And my friends, you will get a very, very detailed knowledge of the subject on which you have asked me to speak. But that doesn't mean that I am shirking my duty. I want to speak to you about it. Now, first of all, those of you who have a smattering of a sort of knowledge of the Indian Constitution knows very well that in the early history of India, the Supreme Court delivered a disastrous judgment. It was a disastrous judgment on the construction of Article 21 of the Constitution of India. The most important fundamental right in the fundamental right chapter of the Indian Constitution is Article 21, which preserves our liberty, life and liberty. And life doesn't mean merely physical existence as an animal. It means everything that makes life worthwhile. Opportunities for education, opportunities for medical treatment, opportunities for good health, for travel, for growth of knowledge, education, everything is a part of the building of life on this planet. So Article 21, unfortunately, was not construed in this great light which thereafter has risen under the scholarship dealing with Article 21. That famous, that notorious judgment delivered in those days, which fortunately is no longer good law today, that judgment said that all that Article 21 says is that your life and liberty can be taken away by law. Once the legislature has passed the valid law, under Article 21 is satisfied, there is nothing more to be talked about by for liberty. Now these were very, very great judges. Four of them who constituted the majority spoke of this kind of a thing which an LLB student today should be ashamed of. But there was at least one judge who redeemed himself, the minority judge in that case. He at least said that I don't accept the majority judgment, and he remains a great, great, great image of a great judge and a constitutional judge. Which judge has finally been affirmed and the majority view has finally been abandoned. Now Article 21, how has it been modified? Article 21 has been modified by a very simple judicial method, that Article 21 has to coexist along with Article 14 and Article 19. Now what does Article 14 say? Article 14, construed by itself, has provided us with two great maxims. First of all, that all things, everything must be done reasonably and without the slightest room for being unlawful differentiation. So that laws must equally apply to everybody and must apply reasonably to everybody is the mandate of Article 14. And my friends, when this old construction of 21 became a subject matter of judicial challenge, it came about by saying that Article 21 does not exist in a vacuum. It exists in good company. That company must also tell us the meaning of Article 21, because these articles must all be read together and given effect to at the same time. Now this is Article 14, but there is Article 19 of the Constitution, which deals with so many fundamental rights: right of free movement, right of freedom of speech, right of forming associations, and so on and so forth. If Article 21 and 19 have to coexist, then every right created by the clauses of Article 19 is also a part of Article 21. And there is one more restriction on the legislative power of Parliament or any legislative assembly or institution, that all laws must be reasonable restrictions on fundamental rights. That is the simple jurisprudence of Indian Constitution. The simple jurisprudence of Indian Constitution is that whenever you impose any legal restrictions by passing law on a human being's freedom of expression, freedom to form friendships, freedom to choose his business or profession and whatever, all these restrictions must be reasonable and they must be advanced, must be imposed for the purpose of helping higher interests to persist so that they are not harmed. You can't go on abusing a person, defaming a person. To that extent, the freedom of speech must be restricted. I agree. But you can't say that you shall not speak at all against some politicians. You can't speak against Modi, for example, which I do now. So my friends, this is a very simple thing that has happened. You read about 30 pages in Datta's book tomorrow. He will give you a copy. I will give you a few pages of those. They trace the history from judgment to judgment, how Article 14 was brought into 19, then Article 19 was brought into Article 21, and then the unity of these three articles has then come to one final conclusion, that all restrictions must be reasonable. If they are not reasonable, it does not matter that Parliament has imposed them by law. In that sense, Article 21 is satisfied, but Article 21 has other content which it borrows from its neighbors. So my friends, Now let me give you an illustration. These days, the investigations are criminal investigations, particularly in very serious crimes, which are a great danger to society. Parliament, also consisting of some ignorant politicians who know nothing more than anything, and any good lawyer, they are passing laws. Now, one law that was passed is called the National Investigation Act. I think it's a law which was passed in this after 2000. Now it is in force. Now this law contains two provisions: restrictions on bail. Virtually, the law has now been changed that court, before it grants bail, must be satisfied that this man is not going to be convicted. Bail becomes useless. Then what does the judge do after a man is charge sheeted and he is brought in custody? You don't give him bail. If you give him bail, you are holding that he is not guilty at that stage. So there must be something wrong with this kind of a law, and that is precisely the change which has taken place. Now I want to tell you some latest contributions. Latest contribution is in a judgment. It's a famous case of Arup Bhuyan, decided in 2011. 2011, 3 Supreme Court cases, page 377. 2011, 3 Supreme Court cases, page 377. It is the judgment of 2 judges of the Supreme Court, and one of these judges, my friends, is Mr. Justice Katju, who is no longer on the bench. It is Katju and Gyan Sudha Mishra, 2 judges. And see the wonderful thing that has happened in this particular judgment. This gives you almost a summary of the whole argument that I want to place before you for your consideration on this particular topic. The rest Mr. Datar will tell you, and I will give you the pages from his book. Go and read them. Now please understand what this judge says. He cites first American cases. He says, paragraph 9, in state of Kerala versus Ranif, we have respectfully agreed with the United States Supreme Court decisions in F. Brand versus Rousset, which has rejected the doctrine of guilt by association. Mere membership of a banned organization, now this is the law laid down, mere membership of a banned organization will not incriminate a person unless he resorts to violence or incite people to violence or does an act intended to create disorder, disturbance of public peace by resort to violence. Now you see that merely making a law is not enough. What they did was they wanted to find a cure for terrorism. But they don't have proper investigating officers. They don't have proper courts. So therefore, find an easy way. If you are a member of a banned terrorist organization and that ban comes from a notification being issued by the executive that this is a banned organization. If you are a member of that organization, that itself is a criminal offense and punishable with life imprisonment. The legislators found that now we have conquered terrorism. Conquering terrorism requires greater talent than merely passing a stupid law like this. And these 2 judge bench had no difficulty in setting aside all these cases of conviction where a person was shown to be a member without any proof, there was not even a proof that that man had taken an oath by membership that I will subscribe to all the objects of this association, and one of the objects is spread of violence or winning an election by violence or by separating Kashmir from India or something like that by violence. Unless that is an ingredient of the offense, said Mr. Katju, that mere membership can't be an offense. Look at this simple proposition laid down by two judges. This is the doctrine of guilt by association, that this association is doing something wrong. Since you have become a member, you must be sharing that objective. This is a proof positive by itself. Mere membership of a banned organization will not incriminate a person unless he resorts to violence or incites people to violence or does an act intended to. And after saying all this, the learned judge set aside the orders of other courts and so on and so forth. And then just see another remarkable judgment coming from the same judge. How the law has been now completely modified, and this is bail law. What the legislature is now doing is to punish people because their investigating machinery is poor, they don't collect evidence, therefore you charge sheet a person, then the trial goes on for years. Ultimately, you may find that it is no case at all. But in the meantime, the poor alleged terrorist has suffered imprisonment for 5 years. So this is what happened now in a judgment of 2011. 2011, 1 SCC 784, the state of Kerala versus Ranif. Now again, this same brilliant judge says, in Scale versus the United States, again relying upon American decisions, Harlan J. of the US Supreme Court, while dealing with membership clause in the McCarran Act 1950, distinguished between active knowing membership and passive merely nominal membership in a subversive organization, and observed, the clause does not make criminal all association with an organization which has been shown to be engaged in illegal activities. A person may be foolish, deluded, or perhaps more optimistic, but he is not by this statute made a criminal. There must be clear proof that the defendant specifically intends to accomplish the aims and objects of that organization by resort to violence. And then in the next paragraph, citing another American case, the Supreme Court holds a law which applies to membership without the specific intent to further the illegal aims of the organization, infringing unnecessarily on protected freedoms. It rests on the doctrine of guilt by association, which has no place here. And then we are in respectful agreement, they say, with these American judgments. And finally see the wonderful paragraph in which what kind of modification of the entire bail law which they provided. The legislature passed a law that you can't give anybody bail unless you come to the conclusion that he is innocent. But then what is the trial for? At the bail stage you will decide whether a man should be, will be acquitted or no. Then why do you hold the rest of the trial at all? The laws are also foolish. But Mr. Justice Katju gave a judgment, paragraph 15 of which today every practicing lawyer carries in his pocket, because he is no longer satisfied with the mere enunciation as exists today in the Unlawful Activities Prevention Act. Section 18 of that Act, 20 of that Act says that whoever is a member of a banned organization will suffer imprisonment, which will extend to life imprisonment. This is what the great judge says. In deciding bail applications, an important factor which should certainly be taken into consideration by the court is the delay in concluding the trial. Often this takes several years, and if the accused is denied bail but is ultimately acquitted, who will restore so many years of the life spent in custody? Is Article 21 of the Constitution, which is the most basic of the fundamental rights in our Constitution, not violated in such case? Of course, this is not the only factor, but it certainly is one of the important factors in deciding whether to grant bail. In the present case, the respondents have already spent 66 days only, and he must be granted bail, because who will then compensate him finally if he is acquitted? Now, this is common sense applied to the construction of laws which are being passed by Parliament. And I must tell you frankly that I am appearing in the Delhi High Court currently for an accused who is a Kashmiri Muslim. He is accused number 1 in the case, but he is a practicing lawyer, and he has been charged with collecting money on one occasion from some people. The prosecution says that they are terrorists. There is no evidence. For 5 years, only 27 witnesses have been examined in the case. 119 are still to be examined in the case, which means that the whole trial will take at least 15 years. For 15 years, this man will remain in custody. And Katju says 66 days this man has remained in custody in spite of all your stupid laws. He will be released on bail. This is the role of the judiciary. This is the rule of the gallant bar of this country. And that is how you will serve democracy, and you will serve humanity, and serve incidentally yourself. And my friends, one more judgment and I have finished. Today, please understand, the law is very simple. The law is that don't deal with Article 21 in isolation. Article 21 also takes added color, which color is not clear from its own words, but it is clear from the words which are associated with it. They exist in the same document, Article 14 and Article 19. That all restrictions have to be reasonable, and these are unreasonable restrictions. And my friends, in the particular case which I told you I am arguing for a Kashmiri advocate practicing. He is supposed to be a member of the Hizbul Mujahideen, which is a banned organization. There is no evidence of his being a member also. But that apart, that I don't know when the turn will come, because 119 witnesses have to be examined. I will be able to establish that he is not a member. But even if he is a member, says Katju, you must allege and prove that he is guilty of inciting violence or terrorism, of which there is no evidence at all. And the judges have postponed the hearing. I argued that matter last week. The judges have postponed it and told the Home Minister that please report to us whether you will consent to bail or no. And I'm sure that a movement is going on. Next hearing, inshallah, the prosecutor will have the sense to come and tell the court that, sir, this innocent advocate has done nothing and he should be released on bail. But this is the latest development in the law, created by judges who know their jurisprudence, who know the spirit of India's constitution. And my friends, once again, please You are the educated section of society. You lawyers are, believe me, the cream of society. I want, before I close in the next 5 minutes, I wish to introduce you to the first lawyer of history. Does anyone know? Please tell me. You don't know. How do you want to become lawyers? You must know the first lawyer of history. The first lawyer of history, my friend, was a man called Daniel. His story is located in ancient Babylon. It is a part of a biblical story of Daniel and Susanna. Babylon was ruled by 4 old men, as was the habit in those days. 4 old men, they ruled this country. And the old men of those days were no better than the old men of today. They suffered from the same weaknesses. And these 4 old men each cast a lecherous glance at this beautiful woman called Susanna, living in that country. They seduced her, they tried to seduce her. But the virtue of the woman was stronger than the solicitations of these old men. She resisted, and these 4 old men brought a false case against her. False case of adultery with a young man unknown. They were the accusers, they were the judges, they were the rulers, they were the witnesses. The poor Susanna was found guilty and sentenced to be stoned to death. A crowd has collected, says the Bible, to witness the execution of this woman. And when the crowd was waiting to see the execution, there was a young man called Daniel who got up from the crowd. He got up and said, I don't believe that this woman is guilty at all. So the crowd was not impressed by his wisdom, but they surely were impressed by his bravado. So there is a young man, but what do you want? He said, I want to ask some questions from these old men. Crowd said, all right, we'll give you. But he said, I want to. He acted quietly like a lawyer of today. You know, today when a lawyer goes to court, he insists that all other witnesses on the same point should be kept away from court, and they should not hear what he is asking one witness, so that they come ready with the answers next time. So therefore they said, all right. So he asked, the poor fellow was not a trained lawyer, but he was high up in his spirits. He asked the first old man, that where did you see this adultery being committed? He said, I saw it in the royal palace. Where? Then he named some section of the royal palace. The second old man was asked the same question. Oh, he says, sir, it took place on the river bank. The third says, oh, no, sir, it took place high up in some tower. All 4 gave conflicting replies, and the Bible records that the crowd which had come to witness the execution of this poor woman was now howling for the blood of these 4 old men. My lawyer friends, please, first of all, pick up the qualities of bravery and courage from this first lawyer of history. He was the first lawyer of history who fought to establish innocence, who fought free without a fee. And that underscores that you shall not deny your services to anybody you cannot pay your fees. I am very proud to tell you a fact which practically every judge knows and every member of the bar knows. I earn money at the bar, but I earn it from 10% of my clients. My 90% work is still free work. And a lawyer has to give free services to anyone who cannot afford to pay his fees. That is his moral and professional duty, now highlighted by rules framed by the Bar Council of India when I was the chairman of the Bar Council of India for 4 terms. All these rules, I have got them framed, and today rendering free legal service is a statutory obligation under the Advocates Act of every lawyer, but those lawyers don't discharge their duties properly. And I hope you youngsters will do that. And if there are any Muslims present, please go and tell your Muslim friends that please try and understand Islam. This is a counterfeit version of Islam that is now creating all this problem in this world. And thank you.